What we heard from the other side here is that this gentleman is the gold standard for prosecution here in the United States. So think about it. We had a witch hunt done by the IRS going after Second Amendment groups, unanimously overturned by the Supreme Court, prosecuted two prominent political figures, and they ended up as mistrials. That's a gold standard here in America?
This may look like a routine oversight exchange, but it's actually a deeper stress test of prosecutorial power in America. What's really being tested here is whether past legal authority was exercised with restraint or driven by political momentum. This raises broader questions about how accountability works when prosecutors themselves escape scrutiny. In this video, we'll break down how prior decisions echo into today's justice system, and why trust in institutions depends on confronting that history honestly.
Yields back. The gentleman from Wisconsin is recognized.
Thank you, Mr. Chairman. In 2010, Mr. Smith, did you work for the President Obama's Department of Justice?
Yes, in 2010, I was the chief of the Public Integrity Section.
During that time, did you have any contact or connection with Lois Lerner with the Obama IRS?
Yes, I was new to the Public Integrity Section. I was the chief. I was trying to learn about issues I had not been at.
Did you attempt to work with Lois Lerner and the IRS to investigate nonprofits?
What I did was I asked for a meeting with the IRS about nonprofits.
So the simple answer is yes.
Well, I didn't ask to work with Ms. Lerner. They sent Ms. Lerner. That's the person who came to this meeting. I met her once.
And they went after Second Amendment groups, correct? If you remember correctly, that's what was the offshoot of it, that Second Amendment groups that tried to gain nonprofit status, they were slow-rolled through the IRS. Do you recall that?
Separate from this, there was an investigation of that that I was a part of in public integrity.
Did you, you prosecuted Virginia Governor Bob McDonnell, this was asked earlier. You prosecuted him, correct?
I was part of the prosecution, yes.
And that ended up with a, that decision ended up being unanimously overturned by the Supreme Court, correct?
That is correct, sir.
Yeah, including Justice Ginsburg joined in on that opinion, correct?
I believe that's correct.
Yeah. You also prosecuted John Edwards and Bob Menendez, and those both ended in mistrials, is that right?
The John Edwards case did. The Menendez case, I had left the Public Integrity Section by the time that case was tried. I wasn't.
So, Mr. Chairman, what we heard from the other side here is that this gentleman is the gold standard for prosecution here in the United States. So think about it. We had a witch hunt done by the IRS going after Second Amendment groups, unanimously overturned by the Supreme Court, prosecuted two prominent political figures, and they ended up as mistrials. That's a gold standard here in America? I would just say this, Mr. Chairman. If Mr. Smith ever works for the Department of Justice again, I would recommend a remedial course on the First Amendment to the Constitution. Before I yield the rest of my time, Mr. Smith, I just have one other question. Is there any historical precedent for an alternate slate of electors to be sent to Congress? Has that ever happened before?
That had happened. Not anything similar to this situation, but you're correct. It was in Hawaii. I think it was Hawaii in, I want to say, the 1960 election.
So it has happened before that there was an alternate slate of electors that was sent to Congress, which does the electoral count, correct?
There was a prior time that an electoral slate was sent where there was litigation and recounts going on.
Actually, there's twice that it happened, Mr. Chairman. It happened in 1876 and 1960 that these alternate electors happened. I'd like to ask unanimous consent to introduce the 1960 Hawaii case.
Objection.
With that, I yield to the chairman.
Just moments ago, in this hearing room, a line of questioning peeled back years of institutional history in a matter of minutes. When Representative Tiffany asked Mr. Smith whether he attempted to work with Lois Lerner and the IRS to investigate nonprofits, the exchange moved quickly from simple confirmation to something far more revealing. A meeting was requested. Lois Lerner was sent. The answer, after careful qualification, was effectively yes. And with that, a familiar chapter of American governance re-entered the record. What unfolded next was not merely about one meeting in 2010. It was about patterns, about judgment, about the consequences of power exercised without sufficient restraint. As the questioning continued, the picture widened, a reminder of nonprofits slow-rolled through the IRS, a reminder of prosecutions brought forward under the banner of public integrity. A reminder that some of those cases did not stand the test of time. One was overturned unanimously by the Supreme Court. Others ended without resolution. And suddenly, the narrative being defended, of a flawless record, of a gold standard, began to strain under its own weight. This moment matters because it forces a reckoning with how authority is justified in Washington. Titles and resumes carry influence. They shape public perception. But hearings like this exist to separate reputation from record. When lawmakers revisit past actions, they are not relitigating history for sport. They are testing whether the systems entrusted with immense power have learned from their own outcomes. When decisions are reversed at the highest judicial level, that is not trivia, that is a signal. And signals demand reflection. The American system is built on the idea that power must answer to principle. Prosecutorial authority is among the most serious powers the state possesses. It is not measured by how many cases are brought, but by how carefully they are constructed, how narrowly they are focused, and how faithfully they adhere to constitutional boundaries. When cases collapse or are reversed unanimously, the issue is not embarrassment. The issue is credibility. Representative Tiffany's remarks cut to the heart of that concern. He did not argue theory. He recited outcomes. He asked the audience to think about what those outcomes say when viewed together. Investigations that sparked national controversy, high-profile prosecutions that failed to hold. And yet, the claim persists that this record represents the very best the system has to offer. That tension is impossible to ignore. This hearing also exposed a deeper question about memory in American institutions. Names like Lois Lerner are not footnotes. They are reminders of moments when public confidence wavered. Bringing those moments back into the open is not about grievance. It is about accountability. A healthy system does not bury its difficult chapters. It examines them openly and honestly to ensure they are not repeated. As the exchange continued, the conversation turned to precedent, to history itself, alternate slates of electors, past elections, prior disputes resolved through lawful processes. Here again, the hearing served its purpose. It stripped away rhetoric and replaced it with facts. Yes, history contains complexity. Yes, disputes have occurred before, and yes, context matters. But invoking precedent requires precision, not convenience. History does not excuse every action taken in its name. It challenges leaders to apply lessons carefully, not selectively. What we witnessed was oversight in its rawest form, not polished, not scripted, but consequential. A reminder that Congress is not merely a stage for sound bites, but a forum where records are tested, narratives are challenged, and authority is questioned. These moments rarely trend on their own. They require attention. They require citizens willing to listen beyond the headlines. The broader implication is unavoidable. Trust in institutions does not erode overnight. It fades through moments like this when assurances collide with outcomes and when confidence is asserted rather than demonstrated. Restoring that trust does not come from dismissing criticism. It comes from confronting it directly, with humility and with respect for the Constitution that defines the limits of power. In the end, this hearing was not about partisan victory. It was about standards, about whether those entrusted with enforcing the law are held to the same level of scrutiny as those they investigate, about whether past mistakes are acknowledged as lessons or quietly reframed as successes. The answer to those questions will shape not just public debate, but the future legitimacy of American justice itself. A free society depends on vigilance. It depends on representatives willing to ask uncomfortable questions and on citizens willing to demand honest answers. Moments like this remind us that the system only works when light is allowed in. And that light does not come automatically. It must be insisted upon. If you believe these moments matter, if you believe oversight matters, if you believe transparency is not optional but essential, support our work to expose the truth. Subscribe to Liberty Report USA.